When viewing this film, we strongly encourage you to review all the primary source documents referenced. Also, please keep in mind that each source needs to be viewed in light of the timeline, the historical context of the writing, and even the politics of the day. If you choose to use any of our current search engines available today for interpreting claims made here in this documentary, they will likely not take you deep enough. Our intention is to invite you to consider things that might not exist in your previous learning, research, or memory to date. It has become evident as our narrative unfolds that history is often written by the conquerors. However, those who were conquered also have legitimate stories. This documentary seeks to present the truth of our histories, the journey, and where we are now. The national flag of Canada. A red rectangle, twice as long as it is wide, with a white square in the middle and a single red 11-point stylized maple leaf at its center. It is iconic, simple in design, and easily recognized. For over 60 years, this flag has been flown from flagpoles, buildings, vehicles, and even backpacks across the landmass known as Canada. Many people cherish this flag, have proudly displayed it, and strongly believe that it represents the people of Canada. They believe it stands for free spirit, unity, and in recent times, even resistance against an oppressive government. The people believe that this flag belongs to them and that it represents the people. But what many do not know, and which will be presented in this documentary film, is that this flag is the exclusive property of a foreign corporation operating under the name Government of Canada. As such, this flag only represents what the corporation wants it to represent, not the people, but the corporation has the sole control of this flag. The corporation dictates the values and identity that are attached to its corporate symbol and trademark, the national flag of Canada. Within the meaning of heraldry, a flag is a piece of cloth that commonly represents the insignia of a sovereign state, an organization, a community, an armed force, an office, or even an individual. Originally, flags were mainly used in warfare, representing the identification of either friend or enemy. National flags commonly represent some aspect of a nation's history, culture, or even religion. For example, the Union Jack, the flag of the United Kingdom, combines the crosses of St. George, England, St. Andrew, Scotland, and St. Patrick, Ireland. The history of the national flag of Canada. The dominance of the British Empire in colonial British North America was symbolized by flying the Royal Union flag, also known as the Union Jack. Originally, this flag was adopted when England and Scotland were united in 1707. The cross of St. Patrick was added to the flag in 1801 when the Union with Ireland was established. Since 1900, the Canadian Red Ensign has been flown from flagpoles across the Dominion of Canada. This flag originated from the Red Ensign, a red rectangle with the Union Jack in the top left corner. This flag was flown by the British Merchant Marine to show peaceful intentions. This flag is the exclusive property of the British Merchant Marine and is the civil ensign that is flown by British merchant and passenger ships. The Merchant Marine is not part of the Royal Navy or the British government. Permission was granted by the British Merchant Marine to the Canadian Merchant Marine in 1892 to fly the Red Ensign on their ships. The Canadian Red Ensign consisted of the original red rectangle with the Union Jack in the top left corner and added a coat of arms toward the bottom right corner. However, the British Merchant Marine never granted permission to fly the Red Ensign from flagpoles across the land of the Dominion of Canada. Although it has no legal status on land, it was unofficially used as a national flag. In 1921, an official coat of arms was granted to the Dominion of Canada by King George, and the Canadian Red Ensign was revised. In 1925 and in 1946, there were attempts to design a distinct national flag. However, those attempts were ultimately abandoned. Both times, William Lyon Mackenzie King was Prime Minister. As Prime Minister, Mackenzie King was appointed to the Privy Council of the United Kingdom on June 20th, 1922. The title of Right Honourable was given to members of the Imperial Privy Council. As described in the documentary film Canada: The Illusion, the Privy Council is a formal body of advisors to the monarch of the United Kingdom. This Privy Council acts as the executive government of the United Kingdom. Prior to the enactment of the Statute of Westminster in 1931, a number of Privy Council members were appointed to assist the Governor-General in the government of the Dominion of Canada. As detailed in the documentary film Canada: The Illusion, the Governor-General ceased to exist on December the 11th, 1931, when the Crown in Chancery gave up the title to the land that was the Dominion of Canada, a British colony. In 1925, that British colony was alive and well. In 1946, though, the Dominion of Canada had already ceased to exist. Each province became a sovereign nation in 1931 when the Statute of Westminster was enacted. Since the provinces never confederated, there has never actually been an independent country called Canada. Not only was William Lyon Mackenzie King an illegitimate Prime Minister in 1946, but as a member of the Imperial Privy Council, he represented Great Britain and not the people of each sovereign province of the landmass called Canada, at a time when Great Britain had already lost all authority and power over that landmass. Given the power and money that comes with an appointment to the Imperial Privy Council, one can speculate with a high degree of certainty why Mackenzie King, who had played a big part in the enactment of the Statute of Westminster in 1931, decided to betray the people and maintain the illusion that Canada was an independent country. The Union Jack remained the national flag of the landmass called Canada, while the Canadian Red Ensign was flown from government buildings. In 1957, the official coat of arms was slightly revised by changing the color of the maple leaf from green to red. In 1964, the Right Honourable Lester B. Pearson proposed a national flag design called the Pearson Pennant to members of Parliament who strongly opposed it. Pearson then created a committee of 15 members to select a national flag. Later, this time became known as the Great Flag Debate. Ultimately, a design proposed by George Stanley, Dean of Arts at the Royal Military College in Kingston, Ontario, was chosen by members of Parliament. Stanley's design was based on the flag of the Royal Military College. Big questions remain as to why none of the 3,000-plus design proposals submitted by the people were considered. Did the Royal Military College represent the people? Who has owned the Royal Military College since its inception in 1876? In January of 1965, the illegitimate Elizabeth II, Queen in Right of Canada, commanded the illegitimate Prime Minister, the Right Honourable Lester B. Pearson, to sign letters patent the proclamation naming the new national flag for Canada. As detailed extensively in the documentary film Canada the Illusion, only the Crown in Chancery, through the Lord High Commissioner, has the authority to issue letters patent. No one else has this authority. Issuing any official letters patent after December 11, 1931 was not only pointless, but in fact impossible, because the Crown in Chancery gave up the allodial title to the landmass known as Canada on that day. That is also the reason why the letters patent 1947, signed by William Lyon Mackenzie King, have been and remain illegitimate, null, and void. On February 15, 1965, during a ceremony on Parliament Hill in Ottawa, the Canadian Red Ensign was lowered and the new national flag of Canada was raised.
He bestowed upon it and us
the patriotic motive that have led Parliament to adopt a new Canadian flag do not include disrespect for our past or for the emblems of that past.
Je fais appel fervent et pressant aux Canadiens de toutes origines, tous ensemble, donnons un exemple de...
Today we salute the future, and for us it will be a great future if we resolve to make it so. Under this flag, may our youth find new inspiration for loyalty to Canada, for a patriotism based on no mean or narrow purpose, but on the deep and equal pride that all Canadians will feel for every part of this good land. Que Dieu bénisse notre drapeau. God bless Canada.
Similar to the deception of celebrating Canada Day on July 1st each year, which was created to keep the people trapped in the illusion that a country called Canada exists, since 1996, February 15th has been celebrated as National Flag of Canada Day to further deepen the deception and the illusion. So, who actually owns the flag? As a heraldic emblem, the national flag of Canada is managed by the government entity called the Canadian Heraldic Authority, which is managed by the Office of the Governor-General of Canada. Detailed information from Dun & Bradstreet, dated February 2025, shows that the Government of Canada is a registered corporation. One of that corporation's main subsidiaries, subcorporation, is the Governor-General of Canada. The Governor-General's Act 1985 states that the Governor-General of Canada is a corporation sole. Since the national flag of Canada is managed by the government entity called the Canadian Heraldic Authority, which is managed by the Office of the Governor-General of Canada, the national flag of Canada is not the property of the people, but the property of a corporation that operates under the name Government of Canada. In a corporation, only those who hold voting shares have the right to vote, and the right and the opportunity to have input. Do the living men and women of Canada own voting shares in this corporation? Are the living men and women equal in status with those that bear the title of Right Honorable? What about the subsidiaries, the sub-corporations such as the Supreme Court of Canada and the Governor-General of Canada? Do the living men and women own voting shares of these corporations? Section 9(1)(e) of the Trademarks Act protects the national flag of Canada as intellectual property of the corporation that is operating under the name of Canada or the Government of Canada. In the interests of clarity and in doing our best to comprehend the rules for persons or citizens to use the national flag of Canada, consider this. While the Trademarks Act restricts the use of the national flag of Canada for commercial purposes, one should keep in mind the definitions of a person and a citizen, which are both considered legal fictions that may be treated like commercial entities. These legal definitions are not the same as the lawful definitions of living men and women. Since the flag is owned by a corporation and protected by the Trademarks Act, which is a statute of the corporation, is it truly a flag that represents the people, the living men and women of each sovereign province? Regardless of how much the people attempt to claim this flag their own, to give it their own meaning and purpose, or to attach their own values to this flag, it will always be the property of the corporation, and it will only have the meaning and purpose that the corporation assigns to it. The Corporation of Canada has not directly granted the living men and women occupying the landmass known as Canada any right to claim or alter this status. Each time you display and wave this flag, you provide consent that you stand with the owner of that flag and abide by the laws that the owner of the flag grants to you. It is, in a sense, no different than waving any branded flag of any corporation and believing that it represents sovereignty and freedom. The National Flag of Canada Act is an act that was passed in 2012 by the corporation operating under the name Government of Canada. In its preamble, the National Flag of Canada Act states that this flag is the symbol of the nation's unity. The documentary film Canada the Illusion presents the fact showing that Canada is not an independent country, but a geographical area that consists of several independent sovereign countries, also known as provinces. Each province meets the definition of the word nation because of the political and territorial sovereignty that was given when the Statute of Westminster was enacted in 1931. Since 1931, this political and territorial sovereignty has been unrealized by the people who are the true sovereigns. De facto, it equals in fact or in effect whether or not by right governments, foreign corporations that do not and cannot hold title to the land, have been deceiving the people ever since. Which nation, then, does this act refer to? The preamble further states that this flag represents the principles of freedom, democracy, courage, and justice, and that it represents all the citizens of Canada. What is the definition of a citizen? Black's Law Dictionary defines a citizen as a member of the civil state entitled to all its privileges. It also defines a citizen as a person, which is a legal fiction and not a living man or woman. Cornell Law School defines a citizen as a person who by place of birth, nationality of one or both parents, or naturalization is granted full rights and responsibilities as a member of a nation or political community. A citizen of Canada is a legal fiction that is subject to the rules, regulations, statutes, and rights that the corporation operating under the name Government of Canada prescribes and grants. A living man or woman is not a citizen, but provides consent to be treated as a citizen by applying for a Canadian passport, for example. As a citizen, you do not have the right to use the national flag of Canada for anything other than what the owner of the flag, the corporation operating under the name Government of Canada, permits. Section 2.1 of the National Flag of Canada Act states that all Canadians are encouraged to proudly display the national flag of Canada in accordance with flag protocol. Interestingly, the established flag protocol as published by the government does not seem to authorize that the national flag of Canada can be worn, carried, or waved by an individual other than those in positions of honor in a procession. It is further interesting to note that the rules applied by the federal government are mandatory for use across all federal properties and during federal events, but are in no way mandatory for individuals or organizations. They may serve as guidelines for all persons, which are legal fictions, who wish to display the Canadian flag and other flags in Canada. And the manner in which flags may be displayed in Canada is not governed by any legislation, but by established practice. This raises the question of whether or not the National Flag of Canada Act applies to living men and women, and if it gives living men and women the right to display the flag. If so, then is the following an overreach?
We are not limiting freedom of peaceful assembly. We are not limiting people's freedom of speech.
On February 14th, 2022, Prime Minister Justin Trudeau invoked the Emergencies Act, which is a statute that was implemented in 1988 with the sole purpose of granting extraordinary powers to the Government of Canada to respond to public order emergencies. Trudeau justified his actions as a response to ongoing protests against his government.
This is about keeping Canadians safe, protecting people's jobs, and restoring confidence in our institutions. We cannot and will not allow illegal and dangerous activities to continue. We're not suspending fundamental rights or overriding the Charter of Rights and Freedoms.
Deputy Prime Minister Chrystia Freeland explained in detail how the government would instruct financial institutions to freeze or suspend the bank accounts of those who participated in the protests without the need for a court order.
It gives me no pleasure to impose any of these measures. In fact, we do so with great sorrow. But do not doubt our determination to act, to defend our democracy.
The clearing of protesters from the area quickly escalated when law enforcement officers decided to use violent measures such as physical force, pointing firearms and other weapons, then the repeating beating of people and horses to trample over people. How was it possible for the corporation that operates under the name Government of Canada to take such drastic measures against peaceful people in a peaceful protest? Why did the police force choose violence? Did the police work for the people, or do they work for the corporation? Are the police perhaps a sub-corporation? Who pays the police? As we established earlier, the national flag of Canada will always be the property of the corporation that operates under the name Government of Canada, and it will only have the meaning and purpose that the corporation assigns to it. Each time you display and wave this flag, you provide consent that you stand with the owner of that flag and abide by the laws that the owner of the flag grants to you. Earlier, we raised the question of whether or not the National Flag of Canada Act applies to living men and women, and if the Act gives living men and women the right to display the flag. Given that question, and since the protesters were waving the National Flag of Canada, thus signaling to the corporation owning the flag that they would abide by its laws, did they perhaps, in fact, violate those corporate laws through the action of protest? Does the National Flag of Canada Act permit the people to wave the National Flag of Canada in protest against its owner? No, it does not. When Trudeau made several requests to the protesters to stop the protest and leave, is this not identical to an officer of a corporation asking a group of employees who are violating the laws of the corporation and who are thus in breach of contract to leave the premises? While these questions and conclusions do not excuse the measures that were taken by the de facto government, they nevertheless provide compelling arguments as to why and how the de facto government was able to act this way. If the protesters had instead waved the flag of parley, a white flag that is used as a visual signal to request a ceasefire or to initiate a discussion between opposing sides, and not the symbol and trademark of the same corporation that they were protesting against, Justin Trudeau would have had no statutes on his side to justify what he did. Most people provide their social insurance number when opening a personal bank account, which then opens the door for the de facto government to control such bank account at their will. With that tacit agreement and the consent to abide by the laws of the corporation, the people give up their right to privacy and private property. The corporation is then within its right, based on internal corporate statutes, to penalize those who disobey the corporate laws and who it thus deems to be a threat. On January 23, 2024, the Canadian Federal Court ruled that the invocation of the Emergencies Act was unreasonable, unjustified, and that it violated the Charter of Rights and Freedoms, in particular, Section 2B, the right to freedom of expression, and Section 8, the right to be secure against unreasonable search or seizure. The documentary film Canada the Illusion presents in detail that the Charter of Rights and Freedoms was never ratified and enacted. Not only has the signature of Quebec been missing, but a second proclamation to enact the Canada Act 1982 has also never been made to this day. Which Charter of Rights and Freedoms is the federal court then referring to? Is this a prime example of how the court, which is a sub-corporation of the corporation operating under the name Government of Canada, keeps the people trapped in the illusion that there is a country called Canada that allegedly has a constitution, which it does not? Does the court give the people the illusion of a win from time to time, just to ensure that the people would never question the legitimacy of the alleged Constitution and Charter of Rights and Freedoms? When truth is stranger than fiction. As a registered foreign corporation, the Government of Canada files annual reports with the Securities and Exchange Commission, SEC, of the United States of America. In Exhibit D, titled Description of Canada, and which is attached to the annual filings, the corporation not only makes false statements with regard to Canada and its history, but it also admits that the Constitution Act of Canada was never ratified and enacted. Let's refresh what we have already learned about the Constitution Act 1982. In 1982, Pierre Elliott Trudeau initiated the grand deception that is called the Constitution Act of Canada, also known as the Charter of Rights and Freedoms, an illusion, as we will see, which many people strongly believe to be factual truth. Trudeau is said to have patriated, which means transfer legislation to an autonomous country from its previous mother country, the defunct and meaningless BNA Act 1867 to Canada. Why did he only bring a photocopy? Why does the original BNA Act 1867 still reside in the parliamentary archives of Great Britain? Trudeau urged all provinces to ratify the document, which is give formal consent to make something official, so that Canadians could enjoy their new constitution as soon as possible. Did all the provinces sign? Was it ever ratified? No. Section 58 states that this act would come into force by proclamation issued by the Queen or the Governor-General if the conditions of Section 59 were met. Section 59 is equally important to comprehend. It states that, paragraph 23(1)(a), shall come into force in respect of Quebec on a day to be fixed by proclamation issued by the Queen or the Governor-General under the Great Seal of Canada. It further states that a proclamation under subsection 1 shall be issued only where authorized by the Legislative Assembly or Government of Quebec, at which time Section 59 would be repealed and the entire Act be renumbered. The key phrase is in respect of Quebec. Section 23 provides details with regard to minority language educational rights. The phrase in respect of Quebec in connection with Section 59 and paragraph 23(1)(a) means that only Quebec would lose its educational right in the French language. Why would Quebec ever agree to this? Subject to Section 59 means 2 proclamations must be made before the final proclamation to pass the Act could be made. Nothing was passed. Nothing was enacted. There is no Constitution. There is no Charter of Rights and Freedoms. Even the 1987 Meech Lake Accord and the 1992 Charlottetown Accord failed to enact the Constitution Act of 1982. In Exhibit D, titled Description of Canada, and which is attached to the annual filings with the SEC, the Corporation Government of Canada, not only makes false statements with regard to Canada and its history, as stated earlier, but it also clearly admits that the Meech Lake Accord and the Charlottetown Accord were not successful in enacting the Constitution Act 1982. In one section, it states that governments set aside the constitutional issue. The corporation that operates under the name Government of Canada clearly admits in official documents that the Constitution Act 1982, with its Charter of Rights and Freedoms, was in fact never enacted. The statement that Quebec is legally bound by the Constitution Act 1982 is false and misleading, because Quebec cannot be legally bound by an act that was in fact never enacted. The statement that an alleged Canadian constitution was repatriated is misleading because Pierre Elliott Trudeau only brought a photocopy of the unusable BNA Act 1867 to Canada. This document has had absolutely no validity whatsoever since December the 11th, 1931, and can never be reenacted or used by anyone.
The Canada Act 1982 is an act that was passed by the Parliament of the United Kingdom on March 29, 1982. Section 1 of this act references the Constitution Act 1982, which forms part of the Canada Act 1982 as Schedule B. The Parliament of the United Kingdom has not had any executive power or authority over the landmass known as Canada since December the 11th, 1931, when the Statute of Westminster was enacted. Since it is a statute of the United Kingdom, the Canada Act 1982 is an unlawful act with regard to each sovereign province of the landmass called Canada, and it does not apply to the people of each sovereign province. The schedule to the Constitution Act 1982 renames the BNA Act 1867 to the Constitution Act 1867. It also renames other BNA Acts accordingly. Since the BNA Act 1867 and subsequent BNA Acts always have been and still are the property of the Parliament of the United Kingdom, that Parliament can certainly rename their acts to whatever they please. But this has no meaning whatsoever for each sovereign province of the landmass called Canada. This deceitful act of renaming historic documents, which became irrelevant on December the 11th, 1931, contributed to the illusion that a country called Canada exists and that it has a constitution, which it does not.
The Corporation Government of Canada has repeatedly issued bonds and registered those with the SEC. What is possibly used as security for those bonds? And what gives His Majesty and Right of Canada the authority to issue bonds worth billions of dollars? To answer these questions, we need to refer back to the Statute of Westminster 1931. Prior to the enactment of the Statute of Westminster, the Government of Canada was composed of a Governor-General and a select committee of the Imperial Privy Council. Any member of the Imperial Privy Council was a member of the Government of Canada. The House of Commons, the Senate of Canada, the Privy Council for Canada, appointed by the Governor-General, and the Lieutenant Governors of the province were to aid and advise the Governor-General in the government. The Governor-General was the sole government. Neither the Legislative Assembly nor the House of Commons were responsible to the Canadian people. They were responsible to the Governor-General only. The first letters patent to constitute the government were issued to James Murray, appointed as the first British governor of the province of Quebec in 1763 by the Lords of Trade and Plantations for the province of Quebec. These are documented as Sessional Paper Number 18 in the official archives of the Dominion of Canada. The Dominion of Canada was defined as a colony of Great Britain. By means of Section 6 and 12 of the BNA Act 1867, the Crown in Chancery ensured a continuance of executive government exercised by the Governor-General, which was first established in 1763. Canada could not have two central governments. The letters patent issued to James Murray in 1763 already constituted the executive government of the colony. The BNA Act 1867 did, therefore, not constitute the Dominion government. It only strengthened the authority of the Governor-General. Each Lieutenant Governor, appointed by the Governor-General, was also a corporation's sole, acting as the representative of the Governor-General and not as a representative of elected representatives or the people. It goes without saying that the Statute of Westminster is the most important document in the history of the landmass known as Canada. Let's look at the key sections and subsections of the Statute of Westminster that apply to the Dominion of Canada. Section 2 removed colonial law from the Dominion of Canada. Recall, the Dominion of Canada was defined as a colony of Great Britain. Section 11 of the Statute of Westminster severed the connection between the Dominion and a colony of Great Britain. What does this mean? The key word is notwithstanding. It means Section 11 overrides the Interpretation Act of 1889, which defined the word colony. The provinces were not joined as one colony of Great Britain any longer. This section also removed the Governor-General because the Crown in Chancery, who is the only one who can appoint a Governor-General, lost the title to the land. Remember that it was the Crown in Chancery that held the title to the land. Without the title to the land, there's no authority to govern, since sovereignty can only be exercised by those who hold the title to the land. Since the Governor-General was the sole government, the Crown in Chancery could no longer appoint a Governor-General. There is no intermediate status between that of a colony and that of a sovereign state. No confederation happened because the provinces had never been sovereign states. Section 11 finally raised each province of Canada from the position of a colony to that of a sovereign state. Section 7 is misleading in how it deals with the applicability of this statute to Canada. Subsection 1 attempts to exclude the BNA Act from this statute. However, the BNA Act was only a statute or guide of the Imperial Parliament to aid the Governor-General. It could only be effective if there is a duly appointed legitimate Governor-General. The executive government was already constituted with letters patent in 1763. The monarch has had no executive power since 1660. The BNA Act 1867 simply ensured that the powers of the Governor-General from 1763 onward extended to the Governor-General for the entire Dominion of Canada. However, Section 11 removed the Governor-General, and nobody else can use the BNA Act. As a result, this subsection is redundant. We can only speculate at this time that those who enacted the Statute of Westminster were perhaps not fully aware of the massive implications of Section 11. And while the BNA Act is a live document today, it can only ever be used by a Governor-General that has been duly appointed by Great Britain. That is impossible due to Section 11. Subsection 2 clarifies that Section 2 of the statute, removing colonial law, also applies to any of the provinces. This makes each province a sovereign state, nation, or country because confederation never happened. Only sovereign states can join into a confederation, and the provinces were not sovereign until the Statute of Westminster, 1931, was passed. Subsection 3 clarifies that the provinces can only act within their boundaries and cannot impose laws on any other province. The requirement in the preamble that the parliaments of all the dominions and the UK must agree on any changes does not apply because Section 11 removed the status of dominion. We can again only speculate at this time that those who enacted the Statute of Westminster did not fully comprehend the massive implications of Section 11, and perhaps that was the intent of Russell Roger Smith, who was supposedly consulted by William Lyon Mackenzie King during the finalizing of the draft of this statute in 1930. So let's briefly review these points again. Section 2 removed colonial law from the Dominion of Canada, which was a colony of Great Britain. Section 7 removed colonial law from each province. Section 11 removed the status of colony. which immediately ended the Dominion of Canada because the title to land was held by the Crown in Chancery. Section 11 also immediately removed the Governor General, who could only be appointed by the Crown in Chancery. There is no intermediate status between that of a colony and that of a sovereign state. Sovereignty and the ownership of land go hand in hand. No confederation happened because the provinces had never been sovereign states. Each province of Canada was now, for the first time, a sovereign state. This status has not changed since December 11, 1931. No province has held a constitutional assembly by the people. No province has seated a de jure lawful government by the people. As a result, every politician, every governor general, every prime minister, every law, every act, everything has been illegitimate since December the 11th, 1931. Anything that was passed after this date is not applicable to the people of each province. The people, the living men and women of each province and territory, have been the sovereigns of each respective province and territory since December the 11th, 1931. Neither the corporation that is operating under the name Government of Canada, nor the Crown and the Crown in Chancery, or the British monarchy has had any title to the land since December the 11th, 1931. So again, we ask, what then gives His Majesty in Right of Canada the authority to issue bonds worth billions of dollars? What is used as security for these bonds? Neither the Corporation, Government of Canada, nor the Crown and the Crown in Chancery, or the British monarchy has any right or authority to use any of the land with its mines and minerals or any private property of the living men and women, including their wealth, as security for issuing and registering such bonds with the SEC. The SEC clearly states that any misrepresentation is a criminal offense. Since the Corporation Government of Canada has clearly been committing fraud for a long time, and has even admitted to doing so in the documents that it has been filing with the SEC, should the SEC perhaps investigate this corporation? Finally, why does the report from Dun & Bradstreet show that the Corporation Government of Canada has a very low credit score with a moderate to high risk and a probability of delinquency of over 27%? What does the future hold? A foreign corporation that has been operating under the name Government of Canada, a de facto government, has been deceiving the people on the landmass known as Canada since December the 11th, 1931, when the Statute of Westminster was passed. Again, since December the 11th, 1931, every law, act, statute, bylaw, regulation, etc., has been unlawful and only represents an internal corporate statute. However, through tacit agreement, the people provide their consent to abide by these internal corporate statutes. The de facto government controls the people through their consent. In contrast to 1776, when the colonists of the 13 British colonies to the south had to fight a violent war to gain freedom and independence, the people of each sovereign province and territory have had full freedom, independence, and sovereignty since December the 11th, 1931, and thus do not need to fight for it. The sovereign people of each sovereign province simply need to hold a constitutional assembly to determine and ratify a constitution for their province, but strictly without any corporate interference whatsoever. None of the corporate politicians need to be asked for permission. None of the unlawful acts, such as the Clarity Act 2000, need to be taken into consideration at all. Why? Because they only apply to the corporate illusion and not to the sovereign people, the living men and women of each sovereign province. No attorneys, lawyers, judges, legal scholars, or so-called constitutional experts should be allowed to participate in any decision-making. Advice and consultation can certainly be obtained, but it is strongly recommended that such advice only be from truly independent outside sources such as legislative councils and sheriffs from a selection of sovereign states or republics of the United States of America. The corporation that has been operating under the name Government of Canada, with all its subcorporations and including the corporations that operate as municipal governments and provincial governments, must be held accountable, dissolved, and replaced, together with all their symbols and trademarks, which include the national flag of Canada. Waving and displaying the Canadian flag is not a symbol of freedom and free spirit, because it is the symbol and trademark of a corrupt corporation. When you wave this flag, you are submitting yourself to the color of laws of the corporation. Regardless of how much the people attempt to make this national flag of Canada their own, to give it their own meaning and purpose, no matter how much the people try to attach their own value to this flag, it will always be the property of the corporation, and it will only have the meaning and purpose that that corporation assigns to it. The corporation has not granted the people any right to change any of this. One may argue that this symbol and trademark of the corporation, the national flag of Canada, could perhaps be used for a new purpose once the corporation has died, once each province and territory has ratified a proper constitution, and once the provinces have agreed on an actual confederation. But why? Why keep a flag that has been based on lies and deceit, a flag that was not chosen by the people, a flag that represents slavery, theft, and fraud? Perhaps it would be better for the people to choose a new flag, a flag that represents their values, their freedom, and their independence. To wrap up, here is a quote from Soren Kierkegaard. "There are two ways to be fooled. One is to believe what isn't true. The other is to refuse to believe what is true."